Welcome to this lecture on judicial review and democracy. This is a RED-SPINEL lecture in the series of the RED-SPINEL project. Our speaker is Christina Eckes, Professor of European Law. Before I say a few words about the lecture, I would like to say something about RED-SPINEL, which is a Horizon project. Some of us, and apologies, I didn't introduce myself. My name is Kati Cseres. I'm an associate professor working at the Amsterdam Center for European Law and Governance. And some of us work in this Horizon project, RED-SPINEL, which is being coordinated from the Université Libre de Bruxelles. And it's a project which is aimed at unpacking emerging dissensus vis-a-vis liberal democracy and looking at various instruments and norms that could be mobilized to address this problem. Today, Christina is going to discuss what she calls a stubborn criticism with regard to strategic climate litigation, which is very much her expertise, and she has received also an ERC grant to further research that. And her claim is that this criticism, which is centered around the fact that court decisions lack democratic legitimacy, is basically not correct, if I understand correctly, and you will show a number of ways to show how courts can indeed engage in democratic decision-making. So the floor is yours.
Many thanks, Kati, many thanks. Yes, the paper I want to present to you today is actually, let's say, not a summary, but it comes out of my ERC project, so it's very much influenced by that thinking, so I've been thinking about it for a very long time. However, in May 2024, I don't think we can speak about the democratic consequences of climate litigation without considering the recent decision of the Strasbourg Court, of the Court of Human Rights in Klimasenioren. So that's what I would like to start with. And then I will take you to my paper. And in that context, I would like to show you that actually the Klimasenioren decision in so many ways confirms exactly what the, let's say, the doubt of the academics that strategic climate litigation is bad for democracy, or at least those that argue that there could be contributions made by strategic climate litigation. And you can hear my formulation is careful for several reasons. First of all, we have just started the 5-year project to show what the direct and indirect consequences of climate litigation are. So I have no means to say what the outcome of that project will be. But besides that, I also by today don't want to argue that it is actually any sort of panacea, it's any sort of solution to the problems that we see in adopting climate policy. But I would like to argue that it gives us some ambivalent hope that we see in strategic climate litigation, that it can make a contribution. And in line with that, I would like to start by showing you a tiny bit what I mean when I say that in Klimasenioren, the court confirmed this position. And I think we are not, this helps me to share the screen. Yeah, thank you. Right, so having said that, I would like to start by showing what in Klimasenioren the Strasbourg Court argued and said and held, and how that connects to our argument. So a very brief recap of the decision, and that is simply that on the 9th of April 2024, the Strasbourg Court held that Switzerland was in violation of Article 8 and 6 ECHR, and didn't find it necessary to enter into the discussion of Article 2 and 13. 8 and 6 are about private life and life of family or family life and access to justice, respectively. And in this case, which is the first ever climate case of the Court of Human Rights, and it's also the first case of a regional court on climate mitigation. So it's a very important case. It's a case where the judges held 16-1 in the Grand Chamber. So the case was referred to the Grand Chamber, which happens only to a fraction of the cases. So that already shows that the judges expected this to be an important case. And just 2 minutes on the facts. We have 4 individual applicants, and that is important, from Switzerland, all elderly women. And we have 1 association representing elderly women from Switzerland, bringing this case. And while 1 of the 4 individuals had passed away at the time, but the court accepted that her heirs could continue the case. And the main point that the four individuals and the association make is that elderly women are a particularly vulnerable group, that they are particularly severely impacted by climate change. And they mention then the heat waves, and the individuals show, of course, on an individual basis with doctor certificates how much they are impacted, while the association shows at a more, let's say, statistic abstract level how elderly women are impacted, and highlights that they have a higher level of morbidity and mortality because of climate change. And the case started in 2016 with administrative review and was basically focused on omission. And it was rejected both by the administration and by the Federal Administrative Court and by the Supreme Administrative Court, in essence, because it was seen as a general public interest claim. So in essence, because they argued it's an actio popularis. And we can actually see in the Klimaseniorinnen case that the court mentions actio popularis 38 times. So it's very engaged with that question, because, and that is, of course, explicable by the fact that this is why the Swiss authorities rejected the case. What is also interesting is that in the national proceedings, the courts did not find it necessary to look into the interest of the association. So they said it is unnecessary to determine whether the applicant association had any interest, because they declared the individual's cases admissible and the association hence inadmissible, without pursuing the question of whether they had actually a specific interest. Ultimately, they said they are not particularly affected, so elderly women, and there's not sufficient proximity. And this is how they rejected it, as I said, in several instances. The last time, the Federal Supreme Court in 2019. And yeah, from that flows, or maybe I want to make one little side note still. What is also interesting in the case of the Federal Supreme Court, that it said that we are far away from the 2 degrees long-term temperature goal. And for that reason, we still have time, I quote, still some time to prevent global warming from exceeding this limit. So I think many people have quoted this as a complete misrepresentation of anything that we read by the IPCC or other scientific bodies about climate change. And I find that an interesting side note maybe to make. As I said, it was rejected mainly on the point that it's an actio popularis and that there's no room for this. And what is, it came to the Strasbourg court. The Strasbourg court found, as I said, this violation, established a positive obligation. And yeah, and this is actually the outcome of the case. But however, I want to, so the positive obligation, maybe add that this is all less unusual than it has sometimes been portrayed in the reporting on it. I want to look at what is actually new in Klimaseniorinnen. And what is actually new is this very tailored approach. So the court says we have a lot of case law on environmental matters, and we take that, of course, as a starting point. However, climate change is exceptional. It is an unprecedented issue, in the words of the court. It has key characteristics and circumstances that are significantly different from environmental issues. And for that reason, we do need a tailored and approach that actually acknowledges the specific particularities. And in that context, it mentions that there's no single source of harm, so that it's a level of aggregation, mentions that anything we do all day long produces CO2, which as such is not toxic per se, but only in its aggregation, that there is no regard for borders, so there's no difference in which jurisdictions you are, where the harm hits you and where the emissions have effects. It highlights the chain of effects so that it's complex and unpredictable, that we have higher emissions, global warming, which leads to extreme weather events, and these extreme weather events such as heat waves, rainfall, and storms then lead to wildfires, floods, and landslides. So further extreme events that harm human rights. In addition, it also highlights that the polycentric issue, and that will come back in a moment. Polycentric issue, it doesn't mean that it comes from all sorts of sources, CO2, as we have already learned, but that we have a wide range of actors and sectors that need to be involved to reduce emissions, so that both public and private actors need to cooperate and all take action, because we need basically green transformations, as the court calls it, throughout society. It emphasizes the intergenerational burden sharing, which gives a little glimpse that the court didn't only look at Klimaseniorinnen, the case that in which it actually gave a ruling, but also considered the other case that it gave a decision on inadmissibility on the same day, and that is Duarte Agostinho, brought by Portuguese youth on this, and that were joined together before the Grand Chamber. So intergenerational burden sharing, intergeneral justice is something the court mentions on several occasions. And it emphasizes how the aggravating consequences in the future mainly affect future generations. So it makes that difference, and that is, I think, linked to the question of the polycentricity, as the court calls it, so that we have everyone involved in addressing this. And that is that climate change, even if it is an existential threat for humankind, and again, I'm quoting the court, in the long run, does not distract from the short term, where we have the necessity of combating climate change, which involves various conflicts and weighing up of interests, which falls to the democratic decision-making process. And it emphasizes that here judges can only have judicial oversight. And again, at this point and different other points of the court judgment, it emphasized that it's for national courts to do so, which also gives us an idea maybe why the Duarte case was declared inadmissible, because in Klimaseniorinnen, as I showed to you, we went through all the applicants went through all instances in Switzerland, while in Duarte they went immediately to the Strasbourg court. So the court emphasized the importance of the national courts in fact-finding and in actually offering an oversight over the democratic process. It came, as I said, to the conclusion that there is a positive obligation of states relating to the setting of a regulatory framework geared to the specific features of climate change. And that is an important point, of course, that there is action to be taken. And I will come back to that in a moment. For the moment, I just want to move forward here, namely to the margin of appreciation. Another point that is new in this context is that the court made a distinction in how to apply the margin of appreciation. And that's very interesting for democracy, as we will see in a moment. And it says that we have a different margin of distinction, margin of appreciation, as regards aims and objectives to combat climate change. So what do we need to do, as compared to the choice of means to combat climate change? So how are we going to do it? And the first is reduced. So reduced, that you have to do something, and you have the normal margin of appreciation, as you have in all other cases, and as flows from the case law of the court, with regard to what you're going to do, which sectors, as it says, this polycentricity and the idea of all actors involved in it, actually. What is further interesting in this case, and it's really a step farther from previous strategic climate litigation that we know, and that I will get to in a moment when I discuss the broader context of democratic consequences, is the duty to quantify. And here, the court says that there's no established methodology to determine a country's carbon budget. It refers here to the German Constitutional Court in Neubauer and says that we don't have this methodology, but, and it refers in this context to the common but differentiated responsibility principle, and says that this principle requires the state to act on the basis of equity and in accordance with its capabilities. So it, on the one hand, acknowledges that there is no such thing as one methodology to establish this carbon budget, the national carbon budget, but that there's a procedural obligation to quantify it. Switzerland, in this case, said we have an implicit carbon budget. So our carbon budget flows from all our policies, our climate mitigation policies, and the Strasbourg Court said explicitly that that is not enough. An implicit budget, the court says something like, I cannot see how that can meet the obligation. So you do need to say how you quantify your national carbon budget. And you have to do it, and that's an important second part, in light of what your part is. So the court says every state has to do its part. This is a reference to the whole fair share literature that we can also discuss in a moment, but the essence of it is that you have to take equity principles into account. You cannot simply deduct your share from the global carbon budget in a linear fashion, but have to take into account what the specific contexts of your state are in light of equity. Then the court established a procedural duty to offer appropriate opportunity for associations to contest climate policy making. And that is another aspect that is new and different in this judgment, and that is very interesting, and where the court really goes out of its way to explain the role of associations in complex modern societies. It speaks in this context of a vehicle for democratic representation. And that is very far-going. It does so by referring 50 times to the Aarhus Convention. We have found, while on a side note saying that the Aarhus Convention is not applicable, and Stefan Trapp, sitting here, will together with me explore this further as one aspect of the judgment where we're still a bit puzzled how you can refer more than 50 times to the Aarhus Convention, expressing how important it is that you have public participation, and then on a side note saying that it doesn't apply to strategic climate litigation, which at least cannot be true in this generality. I mean, we can discuss to which aspects or which cases it doesn't apply, but in this generality, I think that cannot be defended. It then moves to the victim status of the individuals and goes their direct, indirect potential, and explains that there always has to be a link between the individual and the harm, but that can't be pursued here because there's an infinite number of persons affected by climate change. So it makes three, I think, important remarks here and says that, well, basically everyone is affected by climate change. Secondly, the critical issues are usually arising from omission, not from action, hence that states do not do what they need to do in terms of climate mitigation, which makes it particularly difficult to challenge judicially, and that there's deep deficiencies in the regulatory and legislative framework. And that is, of course, something that I will get back to you in a moment in the context of what can strategic climate mitigation do for us in terms of democracy. I find a particularly interesting paragraph, if you want to read it up, 484, where the court makes all these things that it fights with, I think, very clear, saying that if we make this circle of victims too broad, then we basically disrupt national constitutional processes and principles and this principle of separation of powers. However, if we make it too narrow and we don't allow anyone to bring cases because they are not particularly severely affected by climate change, because everyone is affected, then we just deny individuals any remedy in a place where we have a dysfunction of governmental action and the democratic processes. There would be no judicial redress. And I think that shows a bit how the court sort of tries to think about it in many ways. And in that respect, I think while you can still discuss whether the court is respectful of democracy, we have to at least admit at this point already reading the judgment that they're very mindful of the national democratic process, emphasizing to us time and again what role it plays in actually making climate policy. Okay, all this already here very quickly, it has triggered tremendous backlash, and this is a bit going in the direction of RED-SPINEL, and this is something I also took a particular interest in for that reason, namely the dissensus emerging potentially or actually from climate litigation, because it is a landmark case. It is, we already, I mean, the number of blogs produced by academics, but also the fact that it was already mentioned in Shell, in the Shell appeal in the Netherlands, also in the beginning of April, immediately after the judgment came out. We can see that this judgment will have a ripple effect throughout Europe. At the same time, there was a big national media backlash. So Swiss media was extremely critical. There was a letter written by leading academics that was not published in the leading newspapers because they said they had already published so many points on it. But that particular letter was, of course, defending the judgment other than the other opinions saying that it was actually affecting democracy. We had a video of the Swiss judge before the Strasbourg court defending the case that you can also see on YouTube still. And we also had very recently now a committee of the upper house of the Swiss parliament actually rebuffing the ruling and reproducing the same arguments that the Swiss government produced before the Strasbourg court. And we will see what comes from that. Klimaseniorinnen has of course voiced that they expect the Swiss government to comply with the judgment. And yeah, that process is ongoing. But what we can definitely conclude at this point is that the judgment is not unequivocally embraced in Switzerland, but that there's a lot of discussion still about it and to what extent everyone is willing to follow it. Now I move to the paper that I, as I said, wrote way before the Klimaseniorinnen judgment was given, but I just find so many aspects that resonate in the judgment that I found it, very inspiring to read the Klimaseniorinnen judgment, as you have certainly noticed already. And that is that the argument goes as follows. Democracies are not adequately addressing the climate crisis, and they don't fail to do it by a margin, but they fail to do so very big times. And we have, of course, great amounts of evidence for this. The most striking evidence, I suppose, from last year, at the end of last year, I believe September, the actual scientific background paper came out, and then it was confirmed, I think, in December, the global stock take. So the fact that if we continue like this, we will overshoot the 1.5 degrees by, we will go to between 2 and 3 degrees. So certainly much, much higher, 2.5, 3.5 degrees. So the point is we are not doing enough. There's no question about this, and this can in principle not be questioned. And if you look at Europe, where I will pull it back to in a moment, that is even more certainly the case. Judges remain an ambivalent hope. That is my argument in this context. So I say that strategic climate litigation can help us to grapple with the persisting problem of climate change in a positive way. The climate emergency, while it being there, strategic climate litigation may help to strengthen the democratic decision-making process. And this is a procedural contribution. This is not a contribution, as some academics have also criticized, for example, the agenda judgment, for not making a substantive difference. While I think that criticism is not well-founded and the paper is not well argued, I still think that that is not my point here. My point here is a procedural contribution, and mind you, and that's a different form of contribution than substantive. So I don't stand here and I don't defend here that actually as a result of strategic climate litigation, we do reduce emissions one-on-one. That is something that should and is further investigated what the impact is, but it's not the point of the paper today. The point of the paper is that it strengthens representation and participation, that it exposes and addresses pathologies, and pathologies, mind you, is a terminology taken from Eli, which I will explain in a moment. So while you might think that is a very strong wording, it feeds back to that, but I do think it is appropriate in the context of climate policy making. And it leads to a possibility of demanding justification. So strategic climate litigation is another occasion in which the applicants, plaintiffs, can ask the state to justify the lack of its policies in terms of climate mitigation, or the insufficiency of its policies. One main underlying point, and that's also an underlying point for the ERC project that we have just started, and that is why we speak about the direct and indirect consequences for the democratic process, is that the interaction between litigation and the democratic process is more complex than the courtroom. So you have to look beyond the courtroom. It's not only about the established rights and obligations in the courtroom. And one problem of the criticism is that it often fails short of considering more than the actual, strictly speaking, legal rights and obligations flowing from the judgment. And based on this cyclical approach to democratic decision-making, I come to the conclusion that strategic climate litigation is not undemocratic. And just one little disclaimer, I really speak about strategic climate litigation. I do not aim to make a broader contribution to litigation as such, or reviewing state measures more broadly, or anything like that. Okay, so we have a strand of literature saying that judicial review, and now this is a bit drawing from the broader literature on this, that judicial review of state action, hence above all legislative acts, is undemocratic, and that is essentially based on an understanding that judges are unelected and unaccountable, that judicial review brushes aside principles of representation and political equality, and I will get back to that when I look at the climate cases, and that it is that judicial procedures are extremely formalized, and for that reason they cannot offer the same inclusivity, and that only the legislature is able to balance all involved rights and interests. That's a bit in short their argument. Yeah, I'm keeping it short here. We can pursue this further in the question and answers. Then you have people in favor of judicial review of state action, legislative acts. And here the point is that, or the point often made in this context, is that judges are better at protecting fundamental rights. And I just put Jeremy Waldron and Matthias Kumm as important representatives of these strands. I'm not saying I'm only relying on their arguments. Many people have written in one or the other direction. But here the main point is that judges are better at protecting fundamental rights, and that elections are not sufficiently accountable in the sense that they are not frequent enough, that they're too blunt to ensure accountability, that the electorate has already forgotten after 4 years what happened 4 years ago, that it's very much short-term and motivated by issues that boil up in the public debate at that moment. The reason that judges are better at protecting fundamental rights is usually founded in, or the argument is supported by reference to their education, by reference to the procedure, which is more formal and which allows a better follow-up of which right is infringed in which way and can we justify it. Something that I would like to add to this is that when we look at strategic climate litigation, is that you can see that the issues that come up are different in many regards than in the political debate. And here I have followed more closely the Irish climate case, and here we could see that at least all legally relevant issues come up in court, while we have, of course, at least if you follow it via the media, and if you look at individual parliamentary debates, the debate is dominated by issues that are politically opportune, so that can score political points, while judges focus, and that is something that we will also show throughout the project, on different issues. I think that is something we can already establish. Whether we think it's more inclusive, it is certainly different, that there are also issues that come up in litigation that do not come up in the political debate, or are at least not given any weight in the political debate. Then the point, of course, going beyond the courtroom, we are not the first in this project to look at that. So I draw in the conceptual framework a lot on Christina Lafont, who not only has a very beautiful first name, but also is a woman and has written a very good book, No Shortcuts. And here she emphasizes that the agenda setting, well, it's a theoretical approach, but the agenda setting approach that we see beyond the transparency and the involvement of civil society, that it's process related, that it's an exchange, and that and that we cannot boil it down, and that is important, to lawmaking by judges, because that is not at issue here. And we could also see that some of the people defending strategic climate litigation allow this to boil it down to lawmaking by judges, and I think that is a too narrow approach in any effect. So the broad concept here, drawing from, as I said, John Hart Ely, we will look at representation and participation, correcting democratic pathologies, so perfecting the procedure. And in addition, not so much drawing on Ely, but more on Habermas, and centrally on Habermas is justification process related, but also adding the substantive element of reasonableness. So while correcting democratic pathologies and representation and participation are very much process related, and that is also Ely's argument that it is a procedural contribution, it is not value protecting, no substantive contribution. We can see that in the context of justification, while it is still process related, while it is still offering an additional forum where plaintiffs and applicants can ask the state to give a new argument, it of course weighs that argument in light of substantive criteria. So there's an element of substance, because you have to make it reasonable, your argument. You can't just just repeat the previous arguments that you have brought forward, for example. Yes. Democratic failures. So the paper starts very much by highlighting what democratic failures we're encountering. As I said, what is pretty much undisputed is that we have the scientific backing of a global carbon budget, so that the IPCC sets out at which concentration of CO2 and other climate relevant emissions we have, or gases, I should say, we have a certain level of global warming. So there is the causality that is at an abstract level, undisputed, and was also not disputed by any state so far, with the slight exception of Poland in strategic climate litigation. So we do have, at a certain concentration of gases in the atmosphere, a certain level of global warming, which leads to extreme weather events, as I said, and the knock-off effects of that. And that is, I think, generally not disputed. Then we have, of course, the question of what does that mean for the state level? Because I was speaking about the global carbon budget. And here we have, and this is where the democratic failure come in, a number of states that have no budget at all, or anyway, an implicit budget, an implicit calculation of what this means by looking at all their policies and sort of drawing from these policies what that would mean for which level, how many emissions they would emit. And the other question you have, the other group of states, you have no consideration of what is fair in their climate policies. So while they have a reduction percentage and sometimes linked even to a budget, an explicit budget, they don't link it to considerations of fairness. So is this really what we can take from the global emission budget? In addition, of course, as I said earlier, we have the global stocktake. We have statements that, or we have scientific calculations that 2023 was the year in which we had the highest ever recorded production of emission in the world. So the highest ever global emissions. And I think against that background, and the sources I draw on for Europe, and for the states I look at, and now at the state level, not so much at the global level, is the European Scientific Advisory Board for Climate Change that was set up under the climate law by the European Union. You can look at the Climate Action Tracker, the New Climate Institute, Climate Analytics that have submitted also a report in the context of Duarte Agostino, so the case that was declared inadmissible by the Strasbourg Court, calculating that the Netherlands, for example, is at 112% of its national carbon budget in 2030 as compared to 2010. And there you see all the methodologies, and I'm not going to dive with you into these methodologies, but it gives you a sense of how badly the failing is, and that there's ample sources of climate scientists that have established this. But the main criticism is hence that these countries that I look at in this paper, and they're all high-emitting Western states with very few exceptions, don't do their share. What they do is not fair. There is no consideration of the principles. So whatever it may mean, that we say we have equity principles, that we have common but differentiated responsibilities and respective capabilities, and the fact that this is a very open textured norm, what it does mean, and there's no question about this, is whoever has higher historic emissions, higher level of industrialization, and higher level of emissions has to do more than the global average. I think that is something we must all agree on as a minimum. Whatever, how much, and what it means in detail, we can leave aside, and the Strasbourg Court does. But we can say, we can deduct one thing, namely that the common but differentiated responsibility principle can only lead to rich emitting states having to do more. It cannot lead to them having to do less. I think that's fair enough. So, and in that light, we have to conclude it's not fair what they do, and they're not doing their part. And often they're not even doing the minimum. Minimum defined as an average reduction in light of the global carbon budget. And that cannot be enough. There's basically no argument to be made that it is enough. So, democratic failures, wherever you look. So whom are we failing with this? Who are the part of the population of the citizens that are most affected by this. And here I found also the Klimaseniorinnen very illustrative, but let me start by what does it mean globally. If we look globally at what this means, so Klimaseniorinnen says also in my one of my favorite paragraphs, 484, that at a distinct representational disadvantage are those that are most vulnerable, most affected. And I think that is one core conclusion in the European context. And I will explain that I don't look at it globally. There's, again, ample evidence that the global south is considerably more affected than the global north by climate change. But this is not at dispute or not directly at dispute in many of these strategic climate cases, even though, of course, we do have foreigners, we do have those that are not represented joining climate cases in rich, high-emitting states. And here Neubauer, the People's Climate Case, or not against states, but against company. We have Yuya against RWE, we have Asmania versus Holcim. So in many of these cases, you have applicants also from places in the world, such as Indonesia, such as Peru, where climate impacts are much more tangibly felt today in 2024, or when the case was brought a couple of years ago, than in Europe. But that is not so much what I want to forward here. What I want to forward here, because there's some problems with foreigners and their standing, at least in cases against states, which is the main focus of this paper, not so much in cases against companies, is within Europe, the same thing is happening. And here we have much less evidence of it. And that's also what Klimaseniorinnen refers to, namely that also within the European societies, if we stay here for a moment, future generations, elderly, women, poor, less educated, those with health conditions and children are often those that have less political power, either because they are not institutionally represented. If you look at what is the average of the European Parliament, what is the average age of the national parliament in the Netherlands or any other country you take, you have often that not just future generations are obviously not represented, but also young people are disproportionately low in their representation in these parliaments, if you believe that a young person represents young people. But at least we can come to the point that they have institutionally less power. They don't sit on the Supreme Courts. They don't sit in the government, largely speaking. And the same is, of course, true for the less educated. If you look at the level of education in any of these parliaments, if you look at those that have serious health conditions, that are disabled in some way, the same is true at all these levels. And the point here is that strategic climate litigation can offer something in that respect, and that strategic climate litigation can offer an alternative avenue of engagement. And that is not perfect by no means. That is subject to many limitations. But as we have seen, for example, in Klimaseniorinnen, where associations are specifically flagged as a vehicle of collective recourse aimed at defending rights against the threat of climate change, where associations are seen as a level of organization to actually bring governments into action. And where we can see in the particular context of climate change, that is also very much explored in Klimaseniorinnen, but also, I think, very intuitive, that the complexity of the issue of climate change, having all these different sources and polycentricity, is actually requires an organized engagement, so that it's very difficult as an individual affected to actually provide the evidence that at least at a structural abstract level. And of course, the future generations, because we're going into an irreversible path into the future. So there is some limitations, the level of engagement that can rise through litigation, but that is generally in the population, of course, limited. So we have a situation where climate litigation is obviously brought by the few that are very engaged and interested. We have high costs, and it requires a level of organization that not every association can meet. And we have climate risks that are rising from strategic litigation. So maybe that's not so much a limitation, but rather a plus. So even if we don't have immediate effects, what we clearly see is that litigation is mentioned in all sorts of contexts of insurances and banks as a serious climate risk. So we can see that companies in any event are afraid of being sued if they don't do what they should be doing. Pathologies, as I said, I've already showed the democratic failures. Democracy in general is in decline. There's also a lot of evidence of this, plenty of books showing us that generally the level of engagement, the level of trust in institutions is going down in Europe and elsewhere. There's a demand for transparency, which rises in the context of very complex decision-making, which is not just the case in the context of climate decision-making, of course, but which is also the case simply because we live in a more technocratic world where generally the decision-making is based on a level of evidence, of scientific evidence and technocracy that is difficult to follow. But I would like to add something specific for the climate context, and that is that we have a disproportionate level of representation of the fossil fuel industries in all sorts of governance bodies. It's very well documented for the US. It's reasonably documented for the European institutions. It's very well documented for the conferences of the parties under the UN framework for UN Framework Convention on Climate Change, so the UNFCCC. So you can see the number purely of lobbyists from the fossil fuel industries engaging in these political decision-making procedures is mind-boggling. I have not followed it up on the national level in Europe, and it might be slightly different, but I have no means to expect that there's no influence of the very strong fossil fuel industry. You have the campaign of misinformation, and if you ever really want a very bad read before you go to bed, then read the submission of the plaintiff California against the fossil fuel industries, so the 5 biggest fossil fuel companies. They detail the campaign of misinformation from advertorials, where they actually submitted sort of semi-editorial advertisements making factual claims throughout the years in light of what they knew since at least the early 80s, probably longer. Then depends on how long they can get back in the evidence, and submit a big amount of information on what they knew, what they didn't disclose, where they made the opposite claims. So it reminds you, of course, and many people have drawn that analogy of the tobacco industry telling us for many years that smoking is actually healthy. And it's a very good read. So if you're interested, that's what you should dig into. Then in addition, of course, we have these pathologies. We have the short-term memory, and that is something that has been pointed out in many of these cases, Agenda, Neubauer, the Irish climate case, that there is a short-term nature of politics that does not correspond to the long-term problem of climate change, and that there's a big mismatch between what politicians do to stay in office and what we need to do to save the planet. In the Irish climate case, particularly interesting, the court goes at length to say that what we need is transparent public policies, that the public needs to understand why the government is taking certain decisions, and that it's unable to do that if only general points are made. And that, of course, relates also very closely to the idea that you need to quantify your carbon budget. You can't just say, take it implicitly from all my policies together, calculate it yourself. And on that basis, I think what is also interesting to see that in these cases, both in Agenda and in the Irish climate case, actually the state was several times warned that it did not provide any insights in how it got to the reduction percentages that it ended up on. Yes, that much maybe on pathologies. Justification. We have a lack of justification that we see throughout these cases. As I said, they don't give insights, they don't give justifications why they fall under the minimum. When we talk about the minimum, I would like to remind you that's an average on the global carbon budget. So we do know that whatever it is, it's not fair and it's not enough. But even that we don't reach, and we have no justification for the fact that we don't reach this. Then we have the duty to quantify, where of course you would need to justify, namely on which methodologies you do it. As we have heard in Neubauer, the German Constitutional Court, the Klimaseniorinnen case, it has been acknowledged that there's different methodologies throughout on the basis of which you can do this. And there's, for example, the European Scientific Board on Climate Change that I cited, that advises the European Union, has looked at 1,000 pathways. So there's definitely many methods to model. There's different things to draw on. I'm by no means saying there's only one way forward, But if you have a duty to quantify, you of course have to clarify what you're actually doing. And in that light, of course, you have to relate somehow to that substantive minimum that was imposed on states, for example, in the Belgian Klimaatzaak, in the appeal case of last year, and that was imposed, of course, originally in the agenda case. So where the court, in both cases, the court said, okay, yeah, whatever, there's at least a minimum you must do, even if we don't enter into what your fair share could be. Duty to quantify clearly acknowledge that we need to have substantive consideration of fairness, that grandfathering is inherently unfair. So there's a lot that we can take from Klimasenioren in that respect. Judicial review brings back science. Here we have, of course, agenda, the Irish climate case, Grand Sand, Notre Affaire à tous, net zero strategy. We have so many cases where we can see, or Klimaatzaak in Belgium. I mean, basically every strategic climate case relies heavily on science and brings that back to the discussion in a way that needs to be rebutted or at least engaged with. Then we have establishing responsibility. All these courts are, of course, trying to trace what responsibilities states have under law. So what legal obligations have they entered into? And there's, of course, first and foremost, human rights obligations, either under national constitutions, under the ECHR, under the Charter of Fundamental Rights to an extent, if we speak about the European Union, or if we speak about member states implementing EU law. So different sources of fundamental rights. We also have tort law, of course, in first instance in agenda, but also in the Belgian Klimaatzaak. So tort law as a separate private law source of obligation that also booms in the context of companies, obviously, for obvious reasons. And then we have decisions on lawfulness. So we have in these judicial review decisions on what as a minimum is at least not lawful. This does not mean, if you make a decision on lawfulness, that you ask the state to do anything in particular. So as we have discussed in the Netherlands, of course, in many contexts, namely the question of whether the reduction of the speed limit is linked or not linked to agenda, whether the closing of coal-fired power plants is linked or is not linked to agenda. These are all means decided by the government and by the legislator. That is nothing, any of this, that the court in specific indicated as a need to take action. It only took the decision that what was done was unlawful because it wasn't enough. Justification. Here again, the process-related aspect of it. It offers a forum of transparent exchange where scientific soundness is demanded, so where reaction to science is demanded, but also where normative decision of what is fair are discussed. And that's an important aspect. And this is something many judges have shied away from. So we have Matur in Canada, where I think this was the judge that went the farthest to say we are not engaging in what is fair share. We will not review. We will not establish what could be a fair share. And that is something we see, of course, also in the Belgian Klimaatzaak, a clear point that we stick to the minimum to not argue what is fair. But that is, I think, what we need, because these are norms. This is a principle that is legal, that's a legal international law principle. And we do need, as we do for many principles of law, judges to engage with them, to concretize them in the individual case, to give us guidance of what they could mean, because it is a very common thing that an open textured legal principle requires further filling in. Cyclical nature, I've already mentioned this. This is particularly important in the context of multi-layered legal landscape of Europe. So while always policymaking, politics is a circular and cyclical process in the sense that it is naive, and it's a perspective of lawyers that is clearly not shared by political scientists, that any court judgment is the final word on anything. It's the final word on the particular case, on the specific issue, at a specific moment, in a specific legal perspective, framed by who's the applicant, who is the person whose rights are infringed. It really doesn't mean that this is the end of any climate policy, which is also, of course, obvious in the context like agenda, where you are speaking of general climate policy and a minimum, excuse me. But here we see that the government still had to take action, and also anything that was said in agenda related to 2020. So time goes on. That doesn't mean that we have any indication what this means. Or we have an indication, but we don't have an answer what politics should do for 2030, and that's why we have new cases. In Europe, we see this in particular because of the exchange between the EU level, the national level, preliminary rulings, the exchange of judges. What does this mean? Goes back and forth, minimum harmonization from the European Union. So none of these are final words on what should we do. It's an exchange and courts engage in it. In the ECHR, the procedural duty to quantify is, of course, just in a question of how do you think you should justify your national carbon budget? We see it at the UNFCCC and the Conference of the Parties that this is an ongoing process where we still see some movement in different ways. This is also the nature of separation of powers. The national judges give judgments, follow up in the Netherlands and in Germany, for example, where we have a new Climate Protection Act after the Neubauer judgment, where politics came with a new judgment in that light, giving political meaning to the obligations established by the German Constitutional Court. So again, judicial action has so far never exactly specifically determined any follow-up action. Political commitments and action, it's a process in development. Judicial decisions are limited to a specific period and a specific context and never establish what we should do in the future. Also because, of course, we expect technological development and we don't expect to know already what we need to do in 2030. Finally, it's the democracy stupid. If you read Klimasenioren, I really don't believe that you can say it's an undemocratic judgment. It really bends over backwards to avoid actio popularis, motivating line throughout the judgment, that it tries to limit standing for individuals, that it only allows associations is one aspect, but there are many that we now look at. So the democratic dysfunction in climate policy making pointed out here in the case of Switzerland, where really there was basically there was no national carbon budget. There were big deficiencies that the court traces on the basis of the facts established by the Swiss courts in the procedure. We have the standing of association that tries to avoid floods of cases from infinite victims, individuals. We have the specific emphasis of associations and their role in democracy as vehicles of participation in the political context that allows individuals that are otherwise not able to engage with the political institutions to organize themselves. We have the margin of appreciation that I mentioned to you at the beginning, the difference between aims and objectives and means, where it's only reduced for the aims and objectives, so that we do need to do something, not what we need to do. And this is, of course, where we need to balance the interests, because that's where we go through all sectors and where different interests are represented. And we have, and this I haven't mentioned, and I just want to end on this, Duarte is, of course, also a very fascinating judgment. And when you look at the jurisdiction, it's very interesting that in Klimasenioren, the court said that Switzerland has to reduce emissions not only on its territory, which is usually the case, but also from trade. And from trade, that was 70% of the emissions of Switzerland. So it basically said, you, Switzerland, are responsible for the things that are consumed on your territory, that are produced elsewhere, producing emissions. But in Duarte, it took a decision of inadmissibility. It said that the other members, the other contracting parties to the ECHR, hence not Portugal, but the other 32, or later without Ukraine, 31 countries, were not responsible for the harms brought about to the Portuguese youth in Portugal. It was outside of their jurisdiction. And you could say that there's a certain illogical aspect by saying that you're responsible for human rights protections on your own territory. Hence, Portugal was meant to protect. Though in the Portuguese case, first the inadmissibility failed on other aspects, but not on extraterritoriality, as these youth lived in Portugal. So that you're responsible to protect human rights on your territory, at least in first step, even though you can't, because emissions don't respect borders. So what can Portugal do about climate change on its own? As we all know, this is the drop in the ocean argument that was rejected many times, that one country alone can't solve it. So you can say there's a certain level of illogical approach in it, but that's, of course, justified by the whole term and the idea of jurisdiction and the protection of the democratic process. Namely, that if you want to limit emissions from consumption in Switzerland, where would you do that as a state? Through legislation in Switzerland. While if you want to reduce harms of the Portuguese youth from emissions produced in whatever, Germany, the Netherlands, France, Spain, wherever, you would need to do that in legislative process in these countries. So if you think about it that way, I think it is again an argument that the Strasbourg court was very aware of the political process and very committed to protecting democracy in these states. Finally, the Strasbourg court is, of course, a regional court, so it said we cannot allow the Portuguese youth to sue all these other, or to bring all these other countries before the court, because it would lead to an untenable level of uncertainty that you could be brought to the Strasbourg court from anyone in any contracting party for something that the other state does, because it's a regional court. So ultimately here, the consideration of separation of powers, and we will also explore that at length in our project, are slightly different, because the Strasbourg court is obviously not embedded in any particular jurisdiction or any particular or national jurisdiction, domestic jurisdiction, in any particular institutional exchange as the judicial body. Thank you for bearing with me. I know it was a long talk, but there's so much more to say about it. So sure, in the future, I'm just gonna give you another talk on a different perspective. Thank you very much.